Hi, I'm attorney Andrew Thompson with the Thompson Law Office in Carmel, Indiana. In other segments relating to homeowners' rights and mortgages and foreclosure situations, we've discussed the general lay of the land, defenses to mortgages, and we've specifically talked about the issue that's described as mortgage securitization or securitization of mortgages. Okay, in this segment, we're going to talk about the problems that can arise with the promissory note, the actual evidence of the debt that you owe to your lender. So you find yourself in a situation where you're in default on a note. Now, what happens? What happens if it's a credit card? What happens if it's any kind of loan, a car loan? The creditor has to come to you and they have to have a proper accounting for what's due. They don't only have to have a proper accounting, they need to be able to show that they have the right, that they're the real party in interest, okay, to collect on the note, on the debt that's due. Indiana law on this issue gives a lot of protection to debtors by adopting a federal rule that involves a real party in interest. If you cannot prove that you are the actual and real party entitled to foreclose or to collect on a claim of debt, then you don't have any action and your case can be dismissed. Now, obviously in a foreclosure situation that may be easier said than done, but it may not be as difficult as a lot of homeowners perceive, and a lot of homeowners have actually walked away from their homes or their rights because they didn't pursue them. Because here's what happens with the promissory note, and these are the critical issues. Okay, a promissory note is evidenced as a negotiable instrument, and Indiana law has some very clear provisions that describe how and when you're entitled to collect on a note, what must be in place. Okay, let's say that the note was properly executed, and 99% of the time in a mortgage situation, the closing procedures are at least careful enough to make sure the execution of the note was proper. Because basically what it takes is your signature and a valid note and a party to be paid as some certain, and a few other provisions that are always included in a promissory note. So the chances are very, very good that the promissory note was properly executed. It's what happens after the execution of the note that may create problems and defenses for you as a homeowner to having to pay that note or perhaps the full value of that note. And those problems usually come up in the endorsement process. You may have heard of the phrase robo-signings, and you may have read some about GMAC and Bank American, that the problems that they have had in processing mortgage loans, promissory notes, and foreclosures. Okay? An endorsement of a note, like the endorsement of a check, means you're going to pay to the order of or pay to another party what the value or what was contained within that promissory note. In other words, the right to collect on whatever remains due on the note at the time that you accept it. Okay? Now, we can talk a lot about what exactly that means, but let's just talk about the endorsement process itself. The problems that happen are that once a note is endorsed, copies are made. And I don't know if you've ever tried to cash a copy of a check at a bank, but you're not going to get too far if you do that. Now, under Indiana law, the court has a lot of discretion from an evidentiary basis to